Senator Creighton, you're recognized to suspend the regular order of business on House Bill 2127.
Thank you, Mr. President. Members, House Bill 2127 is a lifeline for small businesses, entrepreneurs, job creators in Texas who need consistency and certainty to invest and expand and grow. Look around the nation and you'll see that businesses and families are still choosing to move to Texas beyond any other state because they believe they can be a part of a Texas miracle to have the best opportunity to find prosperity in America. It's our obligation as lawmakers to keep that dream alive, a dream that allows Texas to be the only remaining state where you can start a business in your garage or your kitchen and still have a fighting chance to reach your dreams. Texas leads in job creation, business relocation, and we're the one-way U-Haul rental destination of America. However, this prosperity is not guaranteed, and we as lawmakers cannot afford to take it for granted. If we want to remain the envy of the nation, we must pass this bill to prevent a patchwork of regulations. And for many sessions, I've pursued legislation that address specific instances where activist cities were enacting job-killing ordinances so that we could reverse course on that happening. It's clear that this issue is not going away several sessions later. And that's why the Texas Regulatory Consistency Act, a top priority for our Texas businesses this session, one of the top priorities of the Texas House. That's why we bring this forward again sessions later, after many of us in the Senate have continued to keep this as a priority. This new approach gets ahead of potential overreach in the future, establishing that Texas and the state legislature is the correct venue for decisions that impact our statewide economy. This bill is about jurisdiction, members, and it's also about the state constitution. And just as the federal government is the correct venue within certain areas of the law, the state is best suited to regulate the issues of labor and commerce outlined in this bill. Texas cities will oversee a very long list of issues after this bill is passed, including public safety, transportation, zoning, growth, and many other issues. Members, we know that the rest of the nation still sees Texas as the place to seek opportunity and prosperity. We all know that the Texas economic engine is not an accident. It's a direct result of the policies that we've passed here in this legislative body to encourage investment and to encourage others around the nation to understand that Texas is still the greatest example of hope and opportunity and a future for families if they choose to move here. It's also a direct result of the burdensome regulations and red tape that we fought against. And the Texas Regulatory Consistency Act is perhaps the most pro-business, pro-growth piece of legislation we'll consider this session, not because of what it creates, but because of what it prevents. And this will help these business owners keep their doors open, keep people employed. This legislation benefits Texas's small businesses by letting them be in charge of their own policies. It also benefits large businesses like Amazon, Southwest Airlines, and H-E-B as examples that operate in dozens of Texas cities to understand that regulatory issues and policies that affect commerce should be statewide and not regional. Mr. President, I move suspension of the regular order of business to take up and consider committee substitute for House Bill 2127.
Senator Eckhart, what purpose?
To ask questions of the author.
You yield?
Yes, I yield.
Thank you so much, Senator Creighton. This bill is of particular interest to me, of course, because I come from local government. And so my concern is that I am going to become a local government official again as a state senator because of this bill. I loved being a local government official, but the pay was a lot better. So I have a few questions. Is the legislature prepared to write county and city ordinances? Because this bill will require that.
Senator Eckhart, this bill doesn't require anything other than what the day-to-day should be now within our Texas Constitution and Texas statute.
Well, we'll get to the Constitution in a minute.
As I mentioned in my layout, the state constitution under Article 11, Section 5, provides that no charter or any ordinance passed under said charter shall contain any provision inconsistent with the Constitution of this state or the general laws enacted by the legislature of this state. So rather than you returning to be a local elected official, you're right where you need to be if you're concerned with issues tied to labor or the agricultural code or business and commerce issues or certain finance issues, many issues within the code itself. This is the jurisdiction we should be making decisions on for the impact and the future of Texas businesses, so that statewide is the impact for those businesses struggling every day to comply with varying different municipal ordinances that aren't found with authority either in our Constitution or state statutes.
Do you believe that the Texas legislature sets floors below which local governments should not go in terms of their regulatory authority?
Well, I think I was really direct on exactly that question. I think that the constraints are the Texas Constitution, and with the language in Article 11, Section 5, it's very clear.
May I ask you to answer the question?
Yes, the Article 11, Section 5 is exactly the restraint that you mentioned. So I was answering the question. I answered it in my layout. And I'm
not interested in hearing the layout again. Do you believe that the Texas legislature establishes floors below which local governments may not go?
Fourth time in a row, the Constitution is the floor and the ceiling.
So you believe that the Texas legislature sets both floors and ceilings. Floors below which local governments cannot go, and ceilings above which local governments cannot go. Is that a fair restatement of what you just said?
The state constitution and our state statutes lay that out very clearly, yes.
So let's go to some clarity here. When a contractor who is pursuing a government contract, a local government contract, does not succeed in getting that contract because the local government went above the floor set by state government, do you believe that the legislature should correct that?
Well, obviously, why I'm bringing the bill forward. If I didn't believe that, I wouldn't be bringing the bill forward, right? I mean, cities not staying in their lane is exactly why we have the litigation we have in this state. It's exactly why we have businesses panicking in this state. It's exactly why we have single mom, small business owners from your district in committee every time we open the doors of the committee with this bill on the agenda. For years and years now, the same witnesses and new witnesses coming back, absolutely panicking on how to comply with the litany of different ordinances that are not constitutional, that are not found within the parameters of state statute. So when you mention floors and ceilings, I don't agree with couching it in that way. I think that it's very clear in our Constitution that if the charter itself does not find the authority within the general laws of the state, that they shouldn't be involved in going outside of the bounds of that statute. They should be coming to you or me or other legislators to have a bill that is considered in our public hearings and that, if passed, would have statewide impact on all businesses, not just some trying to comply with 30 cities and their different approaches.
Then I'm going to ask you the same question, but with regard to a ceiling. If a contractor going out for a local bid does not win that bid for local contract because the local contract had something below the ceiling of what's required by state legislation, do you think we should correct for that as well?
Give
What
me
I'm getting at, let me
more
jump to the
granular.
case.
I mean, you're on floors and ceilings. Give me hypotheticals. Yeah.
So if a local government contract goes above the floor of a minimum wage, you think we should correct for that in legislation, correct? Is that fair?
You know, we've seen the different minimum wage policies around the nation that have been enacted in cities like San Francisco and Seattle and many other cities that have caused businesses to terminate employed workers. And yes, it's been counterproductive. Those decisions and those compensation policies should be decided here.
You similarly feel that if a local government contract goes below the ceiling of what's required by the legislature in a contract? What I'm saying is you want them to have no latitude. The legislature should set the floor and the ceiling, and there is no deviation in between that floor and ceiling.
Unless we provide for that deviation. So in the bill itself, you'll have different examples that are tied to payday lending. You'll have different examples tied to, the regulation of pets and the sale of pets. You have different authority allowed through statute, not only that currently exists in statute, but also with what we're doing with this bill.
What if the legislature is silent on a floor or ceiling, says nothing at all, but a contractor loses out on the contract because the local entity put something in that the legislature has never said anything about at all? Whether you're talking about fair pay ordinances or paid sick leave or hiring or scheduling practices, all of those examples fit into the category that you're mentioning. This legislation is not about contracts. It's about jurisdiction and the Constitution. So let's take a different example. What about a developer who isn't getting to build what they want on the piece of property that they own? Should the local entity not be able to do any zoning that we are not specifically prescribing?
Zoning is still allowed in the bill because state statute allows for municipalities, home rule cities to work within that space. So, of course.
I did note that it allows home rule cities roads and taxes. So that's good. We don't have to deal with potholes, pothole complaints. Let's take a third. What about a property owner who's angry about an otherwise legal new neighbor who's moving in? Say a puppy mill. The local government can't do anything about that until the legislature directs them to.
That's correct, Senator Eckhart. Look,
what about a gambling parlor?
I just mentioned the sale of pets in the previous answer. So I'm not going to be able to interpret every code for you. You're going to have to do that.
So true.
Yeah, exactly, and that is the point of the bill, right? That you're making the point to why we need the legislation is if it's found in statute, cities can work within those parameters. If it's constitutional, they can as well. If something in addition to that is needed, they can come to the legislature. That's not radical. That's actually the opposite of radical. That's the norm.
So you think that's the norm? We're going to get to that.
What we've seen with the actions taken by cities, the reason why they're getting slapped down in the courts and they're losing in this effort in so many different categories is they're impatient with the results of the Texas legislature, I guess our conservative results, and they're pushing forward outside that lane, and we're having to speak to that.
So a municipality or any other local government, if they have any inferred authority from the legislature, they still have to wait for puppy mills, gambling parlors, massage parlors, payday lenders, and they have to wait until the legislature specifically acts. Is
No,
that correct?
All of those examples are not going to be any different after this bill passes for the city to be able to regulate them. So, no, every single one of those examples would not be changed at all with this legislation passing.
Well, municipalities already have regulations with regard to massage parlors, puppy mills, and payday lenders, don't they?
They do, and some of them have, sick leave and scheduling requirements and hiring requirements, and some of them give, complete subpoena power to city employees over private businesses. A lot of those different examples, this legislation is speaking to exactly that. So it doesn't matter if they already have it. Some of them, what they already have is not constitutional and not authorized in state law.
So let's go to the Constitution, because you have mentioned that over and over again, and I agree with you about what the actual words say. Where I disagree with you, however, is in what the courts have decided it means. Are you aware that it's long-standing case law that what that provision means is if a home rule city can do anything that isn't specifically prohibited by statute? You're aware that that's the interpretation of that constitutional provision.
That's the difference in a home rule city and a general law city, correct?
So your bill changes that interpretation of the Texas Constitution, doesn't it?
Correct.
So doesn't this require a constitutional amendment?
No, I mean, we act within statute, with 10,000 other bills in this session, just like we're acting with this one.
So you're just eradicating the legal construct of a home rule city?
We're just clarifying and evolving over time with policy as we do every other year, January to May.
But you are agreeing with me that you are eradicating the interpretation that a home rule city can do anything by ordinance that isn't specifically prohibited by statute.
Up to this passage of this bill, yes. That's the difference between home rule and general law.
Thank you. And with regard to occupying the field, I note that the bill specifically says, in a field of regulation, the bill prohibits a city from adopting or enforcing an ordinance regulating conduct in a field of regulation that is occupied by provision of this code. What does it take to occupy the regulatory field? Does it take...
Well, if it's an ordinance tied to pesticides, it would be found in the agriculture code, so that would be occupying that field.
So if the agriculture code says anything about any pesticide, then local governments cannot regulate any pesticides.
And conversely, if the ag code says that local government can regulate pesticides, they would obviously be able to, as they do now.
So if a code touches on an issue, it has occupied the field.
We write statute that's ambiguous on purpose and vague, and sometimes we're very prescriptive and we choose to go the other direction. If it's ultimately decided to be too vague and parties are in conflict over it, then the courts would clarify that.
So it sounds like we're going to have a lot more courts clarifying stuff. Would you agree?
The judicial branch is what it is. That's what it's there for. But no, I don't believe that this bill would enhance any additional litigation. I think it's very clear to most cities in Texas what is in bounds to follow state statute and the Texas Constitution and what is not. That's why most cities are not advancing ordinances like we're talking about, but many are.
Well, when I was a county attorney, assistant county attorney, one of my jobs was to go looking for express authority for the county to act. because counties, unlike home rule cities, can only act when they are specifically allowed by the legislature. So it's true, counties have to go looking for express authority, but cities have not traditionally. Don't you think that that means cities will now lay back and wait for the legislature to act, even though they are governing 365 days of the year 24/7 and we only meet 140 days every other year?
I don't agree that most cities act really much different than counties do. I understand the distinction, and there are some very clear differences, but most cities in Texas understand very clearly that they must act within the state constitution and the powers granted to municipalities, and also within current state statute. But some cities are not abiding by that, and that's what this legislation is about. It's simply a reminder about jurisdiction and making sure that a litany of and a patchwork of different ordinances across this state that are an impossible compliance nightmare for businesses is anti-business, it's anti-growth, it's anti-job creation, and it's anti-Texas to allow those ordinances to be passed. That's what this bill is about.
I can tell you that in working for a county for 20 years, when constituents came complaining of incompatible uses, of the inability for zoning in counties and whatnot, I said, then you should want to be annexed into a home rule city where you can get that kind of service. So basically, you would like all of Texas to behave like a county rather than like a home rule city.
As long as home rule cities are acting within statute and within the provisions of the state constitution, I think that they're well within their right to continue to do what they do and do it well. And as I mentioned, many of them, most of them already do that and already understand through their general counsel and city attorney and city managers what is appropriate business to advance and what isn't. But we have many examples also in Texas and right here down the street where that has not been the case.
Why not just get rid of cities?
Why not get rid of cities? There's no intention it's signaled in any of this legislation to get rid of municipalities or counties or any other local governing entities. But I can tell you one thing. There is, without a doubt, certainty in signaling with this legislation and other bills that a reminder that jurisdiction matters and that the state constitution matters and that our businesses matter, because our businesses are panicking, coming into our hearings and calling into our offices saying, we have to lay people off. We cannot keep up with the compliance differences up and down I-35 alone in the different municipalities that have set these different ordinances.
We're the ninth largest economy in the world if we were our own nation, but you're saying that business is having trouble here?
Yes, I am. And the reason why there is an appropriate tension there is what we do in this building is the reason why we provide the tools to entrepreneurs to take the risk, to create the jobs that bring us that distinction of being the ninth largest economy in the world. But the only difference that you and I would probably have on that distinction is I am striving for number one, not number 9.
If we were our own nation, we would be number 9. We're not a nation, so we can't be the number 1 nation. You're aware of that, right?
It's all based on GDP. We're number 9 over so many nations on this planet. So yeah. I really don't hold myself back on setting any goals, nation or not.
That's a very patriotic statement to make. I'm being facetious.
Appreciate that.
And you are aware that the predominance of that gross domestic product is coming from our home rule cities, businesses inside our home rule cities, correct?
I'm aware, but I'm also aware that when Tesla and Caterpillar and Samsung and others, Hewlett Packard, when they come here, Exxon, it's interesting that many of them choose to be just outside of those home rule city limits and in the county's jurisdiction. And isn't that amazing that those real estate choices and those site selection teams are that careful about avoiding the home rule city boundaries? And it's exactly for reasons like this bill clarifies.
Do you believe that state legislation would have occupied the field if it is silent on the issue?
If it's silent on the issue and it's not prescribed in state statute as granting the home rule city authority, then they would need to approach, just as TML provides a legislative priority list every session. And sometimes we're called into special sessions. We may have one soon. And those types of bills and those types of policy changes would be in the appropriate environment right here in the state capitol to consider, or whether they're rejected or whether they're adopted.
Thank you for answering my questions.
Thank you. Appreciate you, Senator Eckhart.
Senator Menendez, what purpose? You can continue. If you need to take that, I can call someone else. Are you good? Okay, Senator Menendez.
Thank you, Mr.
What
President.
purpose?
For questions of the author.
Do you yield?
I yield.
Thank you, Mr. President. Senator Creighton, I've got a few questions, and I was on page 2 of your bill, just so that I understand correctly, everything that's in each of those sections, if it falls under the Ag Code, business and commerce, finance, insurance, labor, local government, natural resources, occupations, and property, you're saying that in those areas, cities cannot pass an ordinance. Is that how I'm trying to understand exactly what's protected and not protected from cities being able to regulate, and which laws are going to be impacted by this? And so if you could help me a little bit understand this.
Well, it's consistent with my exchange with Senator Eckhart. Obviously, there are a tremendous number of ordinances that are found within the authority granted in these different codes. So we talked about zoning, we talked about...
Zoning gets to stay?
Correct.
Okay.
The zoning is chapters 211 through 250 in the local government code. So we talked about animals, we talked about payday lending. I believe Senator Eckhart mentioned game rooms, massage parlors, public safety, police, fire, jails, community planning, development. All those examples are found within state statute authorized by our Texas Constitution, Article 11, Section 5. And that's why most cities in Texas continue to be in line with the expectations and the jurisdiction that we've provided, but some are not.
Do cities, one of the most difficult to craft but important ordinances we passed a long time ago when I was on city council was our sexually oriented businesses ordinance, because we had to comply with First Amendment rights of these people, these businesses, but we also wanted to make sure they were a far enough distance from schools, from churches, from neighborhoods. And so we worked very hard. We ended up getting sued. We won, but we have a pretty strong sexually oriented business ordinance in San Antonio, which dictates where people can and can't put these businesses. Would this preemption law, do you think that those businesses could sue us based, if this bill passes, and say that the city is now preempting their rights, or that the state now has the right to regulate that?
I do not. There's no disruption with the passage of this bill on any work that you or others in the city of San Antonio have accomplished in that space. That's Section 243 of the local government code, and there is no change. Again, this bill is about clarifying jurisdiction on the ordinances that cities can work within based on the authority granted either by state statute or by the Constitution, and that is one of the examples that is already found in statute.
So payday lending businesses, we have a payday lending ordinance in place? Does that exempt, or does that become?
That's exempt, and the House allowed an amendment on that even further clarified that.
Okay, very good. I know that Senator Miles has an amendment for payday lenders that unfortunately he's not able to be here, but we're planning on presenting. Does the bill affect ordinances protecting non-discrimination ordinances that, let's say again, my city, and I know that cities of Dallas, San Antonio, Austin, Fort Worth, Arlington, El Paso, Brownsville, Denton, and Plano, and others have created a non-discrimination ordinance in order to ensure protections for people based on against discrimination based on their race, color, religion, sexual orientation, public accommodation, employment, and housing practices. Does this bill nullify those non-discrimination ordinances?
It does not. And that was also clarified in the debate with the House author as well. The NDOs are not affected by this legislation.
Very good. I'm glad to hear that. Maybe then obviously the amendment we have later might be acceptable to the author. And then let's see, I think the last couple ones we have here, and I think I heard you, but it was hard to hear. Does the bill affect cities that have passed puppy mill ordinances for the sale and distribution of puppies?
Again, that was another clarification by House amendment during the discussion on the House floor. And so, no, the sale of puppies can continue to be, cats and dogs, animals can continue to be regulated by municipalities.
Thank you for taking my questions. Appreciate it.
Thank you, Senator Menendez.
Senator King, what purpose?
Thank you, Mr. President. Will the gentleman yield for a question?
You yield?
I yield.
Thank you. Senator, I remember 2 years ago, you had this bill, I think, again here, and I had it in the House, and it got through this body and very strongly, and then it got over to the House, and even though all the votes were there on the floor, after a long debate, it had a point of order at the end, and it was unavoidably terminated for the session. And so I appreciate you bringing this back up, and I'm excited the House already passed it out. But I wanted to make sure that the intent, as I understood it, was still the same that it was a couple of years ago. And I'll use Tarrant County as an example. I think Tarrant County has about 40 municipalities just in that one county. And I know that if you're a plumber or if you've got an HVAC company or anything that works around that county in the different cities, that one of the problems they're having today is that you've got people working in Roanoke today, or let's say in Haltom City today, and your headquarters is in Arlington. And then you've got a crew in Haltom City today, and you've also got a crew in White Settlement, and then you've got one over in Saginaw. And then tomorrow, you've got one crew over in Hearst, and another one in Pantego, and another one in Dalworthington Gardens. And part of the problem I know they're having is trying to figure out what rules and regulations that affect hiring practices and breaks and even application forms for employment, vacation hours. If they're a restaurant that has multiple locations, different requirements on how many shifts and how those shifts work. And one of the problems I know they were having that we were trying to address 2 years ago was that these businesses were just having incredible difficulty trying to navigate, even just in Tarrant County, 40 different municipalities. And they functionally could just not keep up with it and were terrified they'd be in violation. Or even the delivery driver, who the delivery company's in downtown Fort Worth, and they're running something out to the airport every day. But in doing that, they would pass through Hearst, Euless, Bedford, Richland Hills, North Richland Hills, Arlington, and maybe even a little bit of Grand Prairie just to get to the airport to drop off a shipping package for a consumer. Will this continue as it was 2 years ago? Is this intended to help alleviate that confusion and help everybody have one set of laws to a great extent, the greatest extent possible, that they're operating on when they're trying to go from this city to this city to this city, and maybe not even driving 3 miles and going across 3 or 4 different municipal boundaries?
Yeah, Senator King, compliance and the ability for small businesses and large businesses to be able to comply with these laws that affect commerce is exactly why this legislation is needed, because the patchwork approach of all different cities having different ordinances that are just an impossible compliance nightmare for our businesses to figure out and unravel, to have to hire additional employees to understand how to navigate those differences. It's a job killer. It's a deterrent to businesses looking to move to Texas. And we need the consideration of any of these types of policies that affect business to be statewide, as statutes in our Constitution depict. So thank you for that.
So that if I've got those 6 Domino's pizza and I'm going to have to move my personnel today because I'm short over here and somebody's sick over here, I want to know that when I'm in Euless or whether I'm going down in the next county over to Cleburne, that all of those labor regulations and things, with the exception of a few special ordinances that are allowed in this, they're all going to be consistent, and I'm going to know that I can move people around, operate that small business, and be able to navigate those waters city to city.
That's exactly right. 2 of the best witnesses we had in committee, and this has been for years as we brought this legislation forward in many different sessions, was a small business owner, a female business owner that owned Cinnabon locations in the San Antonio and I-35 corridor, and then, of course, the owner of County Line Barbecue. And with those different locations and trying to figure out a myriad of compliance conflict in the ordinances that were created that all had different approaches and requirements, they just talked about not only it being a burden, but that they were concerned with the increased cost of compliance, that they were going to have to lay people off.
Well, I can tell you, we own a small business and we've operated in about 13 states. And I can tell you, just trying to figure out 13 different state laws has been an enormous difficulty. And I cannot imagine having a business that's operating city to city to city. So this is a great piece of legislation. Thank you for carrying on the fight.
I appreciate your leadership when you were on the House side as the House author. You did a wonderful job with the legislation, and thank you for just working all through the process this time around, this session, to finally bring this bill to passage. I can't thank you enough. Thank you, Senator King.
Senator Middleton, what purpose?
Will the gentleman yield?
Yes, I yield.
Thank you, Senator Creighton. Bill's really not nearly as complicated, I think, as being led on here today. And I think there's important provision here that actually will allow us moving forward to clear any uncertainty up. And is there not a provision in the bill that allows or requires 3-month notice before a lawsuit is filed to allow local governments to amend their ordinances to come in compliance?
That's correct.
Right. So, I mean, there you go. That's where uncertainty is cleared up in the process, just like that. I think that's important to note. I mean, this is really not creating uncertainty like everyone is saying here today. I will tell you this also, that we need to point out the various fields that are still allowed to be regulated. So I'll just list them off here. Payday lending, natural disaster response, puppy mills, unsafe waste storage, short-term rentals, towing, impounding, regulations, metal theft, electricians, livestock, water restrictions, uncontrolled burns, fireworks, open containers, and overgrown lot regulations. So those could all still be addressed by city ordinance, correct?
That's correct. That authority is found in state statute currently, and are great examples of how this bill doesn't limit cities and what they need to be doing day in and day out. It just makes sure that the state and the state legislature is the appropriate venue for considering any additional authority.
Right, and you pointed out earlier that this bill really reaffirms, our Constitution that says you can't have an ordinance that's inconsistent with the Constitution of this state or the general laws of this state. And that's really the guiding principle and document behind the genesis of this bill, right?
That's exactly right. A fresh look at constitutional provisions that's our obligation each and every session. And for this being the top priority business legislation of the session, it's no surprise that the Constitution is exactly where we should be looking.
Right, and the reason why that's worded that way is the state is sovereign over all at the end of the day because of federalism, where the U.S. government is a creation of the states, as is local government. And so that's why that provision is important, and we're just reemphasizing that point. So thank you for bringing this bill
Those
today.
are great points. Senator Middleton, thank you for working with my office and with me personally through the process on this bill.
Senator Whitmire, what purpose?
To ask the senator a question, will you yield?
Do you yield?
I yield.
Senator Creighton, to just get right to the bottom of this, do you really want to pass this piece of legislation?
I do.
Are you attempting to put the final nail in the coffin of local government?
I am not.
What if I told you it's perceived that this would be the final death blow to local government in terms of the folks closest to their government having a say? This is, would you not agree, going to tremendously set back local control?
So, Dean, we're not in any way setting back local control. We're clarifying local out of control.
Nice comeback. I'm worried about, and I want you to visit with me about the real application of your proposal. You are suggesting that you're doing this for the business community. What about the people of those home rule cities? Can't we consider their concerns at this point in this discussion? How do they influence government that's going to regulate their public safety and welfare? Are you suggesting that home rule cities, voters and constituents, citizens are going to have to come to Austin to see their wishes carried out and their new ordinances carried out? Are you requiring them to come to Austin under your proposal?
Senator Whitmire, I don't distinguish between the citizens, the constituents of these home rule cities. I don't distinguish between them and the mom and pop business owners that are found within that home rule city. They are one and the same. And so those very citizens, as business owners, as constituents, as employers, have been coming to this Capitol building for 3 sessions now as I've carried this legislation, begging for the bill to be passed.
Well, during those 3 sessions that you've mentioned, would you not agree the state is doing real well in terms of startup businesses, attracting out-of-state businesses? So have you perhaps gotten misinformation that mom and pops, and I'd be interested in that definition, that mom and pops are suffering to the degree that would bring this proposal forward?
And when I mention mom and pop businesses, I'm talking about mainly a business that has 50 employees or less.
Sure.
You know, a lot of your local businesses that are, you name it, a myriad of different services.
How about a record towing service? Would that be a mom and pop?
It can be. Some of them are quite large, but yes, it could be a mom and pop.
What if those citizens that I'm speaking on behalf of today are in conflict with a mom and pop operation, such as a tow truck operator? What if the citizens want that mom and pop tow truck operator to do background checks on their drivers? Are they going to have to come to Austin and hire lobbyists to work this legislature, whereas now they can go to their local city hall?
It was made very clear during the House debate and consideration on the House floor. It's been made very clear in 12 hours of consideration on this bill in committees and on the floor that cities can continue to regulate towing.
What about public welfare of animal welfare conditions? Stray animals. Are they going to have to come to Austin, hire lobbyists if they'd like to clean up
Well,
environment in their neighborhood?
you and I both know that they've been doing that for years, even with cities being able to regulate that conduct. That cities still can under this legislation, but even above and beyond that, Ms. T carries a bill every session related to puppy mills. We're going to continue to see advocacy in the halls of the legislature, regardless of whether or not cities are in compliance with the Constitution of this state or not. But yes, I believe those reconcile.
Well, no, they don't reconcile because some cities have more aggressive animal welfare ordinances than maybe a home rule city down the road. So now you're asking them to come to a body that only meets every other year if they're concerned about a matter in their neighborhood. Is that correct?
It's correct that home rule cities can regulate the sale of animals before and after this legislation passes.
What about neutering, the requirement that you spade and neuter your animals? Would that?
Yes.
Would you have to come to Austin and get a lobbyist and get that type of community involvement?
Regulating animals is still within the authority of the city. Senator Whitmire, you can, as far as the code itself, you and I can read the code together, but the bill itself is just about following what's in state statute and our Constitution, which most cities in Texas are doing. There are only a few large cities that are out of bounds following sort of this leftist
and I'm glad you
national
brought
agenda.
that up, because is it not true you're really directing your proposal at 4 or 5, maybe the largest cities? But you do realize it's going to affect all the home rule cities, small and large.
I do, and Euless, as an example, is a city that's not what you and I would consider to be one of the largest cities in Texas, and it recently would have fallen within the parameters of this bill. It's not just the large metropolitan areas.
Did I ask you, and I know partisan politics plays no role today, for sure, but would you not agree most of the cities that are going to be impacted are regulated by Republican mayors and councils? I can demonstrate. I could show you. I could put a face on it. You're really going to challenge more Republican mayors than you are these big city blue mayors. Would you agree with that?
I'm not. I really don't agree with that at all. I don't. This bill is not really anything to do with partisanship. Of course, many of our bigger cities are considered to be. They're called the larger blue cities for a reason. But this isn't a partisan bill. This is a constitutional and a jurisdiction bill. And Dean, the House, in a bipartisan way, voted this bill, into final passage. So. It's not
I was just trying to help
bill.
you recognize, and we had the same discussion when we did Senate Bill 2 with the revenue cap. Most of the jurisdictions that statute covered were actually Republican administrations, which leads me to ask you, do you not have trust in their judgment and their ability to govern locally?
Again, that trust would just be my personal opinion. What our obligation is here is to have statewide impact on businesses, on the compliance for what they can expect within their day-to-day business and commerce, and not regional and patchwork impact that at the end of the day causes businesses to move on, prevents businesses from moving to Texas, and through our testimony in committee hearings causes businesses to lay people off. And so when businesses are terminating employees because of the inability to manage this compliance nightmare and to not be able to navigate city to city to city, we know we have a problem. It's not about me trusting. It's about what's constitutional in the appropriate jurisdiction, no matter who's in office.
Okay, let me digress from it out of my line of thinking and questioning. You keep mentioning the Constitution. That's what you want to follow. Would you not agree that the Supreme Court might be the best government body left to interpret Constitution violations and not perhaps Brandon Creighton or John Whitmire on the Senate floor? I mean, why do you want to enforce the Constitution when you can walk across the street and everyone has a recourse?
Well, I have a lot of pride in who I work with, Senator Whitmire. I mean, our senators on this floor and very.
I do too, but I wouldn't take them over the Supreme Court. In all due respect, folks, I guess most of the members are not attorneys. Would you not agree the Supreme Court is the one left to handle constitutional issues?
Well, I just got 7 words into the same question that you asked just prior. So if I can get to 10 words, I'll answer the question.
So I've waited all day to get to this.
You and I both. Hey, without a doubt, I've waited all day to
agree on that.
Yeah, my answer, Senator Whitmire, is that we have allowed cities to go out of bounds on what is constitutional and what is found in state authority for them, and small business owners in your district and mine, unfortunately, without a budget to litigate whatsoever, have had to find themselves breaking the bank and bankrupting their own families and their own businesses to try to get to the state Supreme Court on these issues, and we have to put a stop to that.
Has the Supreme Court found that they have gone outside of the Constitution?
Courts have found that, and I know you mentioned the Supreme Court, but courts have struck down payday lending requirements and other ordinances that were out of bounds and in conflict with state statute, yes.
Okay, a moment ago, I was trying to represent the citizens that I believe are going to be left out of this consideration. Citizens who ask their local elected officials to pass these ordinances, because I think they will have a conflict with the mom and pop operations. That's the reason they go to city councils and petition, and why they get involved in campaigns, why they vote. Let me go to another constituency that I don't think is being discussed or represented enough in your proposal. The workers. You keep saying the mom and pop are desirous of this proposal. First of all, you must have a pipeline to them that so many of us don't. They haven't been knocking my door down, but maybe they know I support local control. But for these mom and pop operations and startup businesses and those that are moving to Texas, they need a qualified workforce, but they also need a workforce that feels safe. So are you attempting to strike down worker training, worker safety, and accountability to mom and pops for not violating minimum wage laws or length of the day, the shifts? I mean, what about the workers? Where do they fit into your concerns?
If the city is making decisions that falls within the requirements of our Texas Constitution and our state statutes, workers are not in any different situation after this bill passes than they were prior to this bill passing. OSHA requirements on safe working conditions and rest breaks and all of those types of things that are offered under OSHA and even the CDC, they still stand.
But what about local rules and regulations? And I know Harris County just came up with requirements for safety, training, work conditions. If you're over, the temperature reaches a certain degree, you've got to allow your workers to have a cooling off period. I mean, these are all have been local decisions to protect those workers. Do you share my concern that the workers might be left out of the discussion?
Not at all. Most of those trainings are consistent with state and federal law, as they would be, prior to this bill passing, and as they will be afterwards. Obviously at the state level, we have a labor code. At the federal level, there's OSHA and there's CDC requirements, and none of that would change.
So is it your desire for my constituents in Houston and our diverse delegation members, for our citizens, our constituents, if they have a local concern, they're going to have to come to Austin. First of all, they're going to have to wait. If it's in an interim, they've got to wait to the session. They're going to have to talk to people across this floor from small communities like Dr. Campbell. I could name my friend from Lubbock. We're going to have rural Texas, small town Texas making decisions for other communities that might or might not share the same concerns. So we've got to tell people in Dallas, you've got to go talk to West Texas, East Texas senators about things that might be affecting the fairgrounds in Dallas. Is that your desire?
Senator Whitmire, they do that every session. It's called Texas Municipal League and Texas Association of Counties. It's called TASA and TASB and all these other organizations that advocate on behalf of their communities.
Well, we're trying to stop that. You are familiar, there's legislation to prevent those organizations in those cities from lobbying. So you're not going to be able to rely upon them to represent those cities in Austin. You're going to ask Dallas and Houston, Austin, San Antonio, large cities, and as you mentioned a while ago, I think Euless, any home rule city is going to have to travel this state and talk to 31 senators about their neighborhood conditions, what's affecting their mom and pop, even if it's on behalf of the mom and pop. There's an interesting thought. What if the mom and pops want to influence some of the business decisions? They're going to have to come to 31 senators across this great state instead of going down to City Hall like they currently can. Is that your intent?
Senator Whitmire, my intent is for the actions that municipalities take to be constitutional and to be within the authority prescribed in state statute as it's intended. So we have mom and pop business owners in this building all through the session begging for legislation like this to pass, and the other bills that you're talking about that might restrict organizations, that's not within the scope of this bill.
I know, but that's who you referenced that might be able to represent those cities down here, or actually represent the citizens that have concerns. My final question is, do you ever worry about unintended consequences of your proposal? Because it is far-reaching, and you've certainly got your sound bites down and your beliefs down that you're just trying to keep the cities within the Constitution. But do you not worry about your unintended consequences to the workers that depend on ordinance for their safety and the citizens for their direct involvement in governing and controlling their environment and their life?
Senator Whitmire, that's where we differ on interpreting this bill. I look at this bill as a reminder of status quo. You look at this legislation as far-reaching and dialing back city authority. I don't look at city authority to include giving a city employee subpoena power over private sector business entities. That is just absolutely not anything anyone ever imagined in this building, that cities would have the ability to launch that type of subpoena power with control from a municipal employee against the private sector. And that stigma is a shot heard around the world, where Texas could be considered to be an anti-business environment no matter what we claim. So I look at this as a reminder of the status quo.
I would urge you to consider that an outlier. I really don't think that's the common practice, which one little piece of legislation could correct. Senator Creighton, we are the envy of the United States and the world under the status quo. People are moving here so fast, we can't even build schools fast enough to house and educate their youth. Our infrastructure can't keep up with the growth. I could go the rest of the day talking about how attractive Texas is, our major and even our small town cities are, and you're trying to disrupt, in my judgment, and I think looking forward, I think you're disrupting a really golden goose that is attracting people to the state of Texas. And I hope, for the sake of the state, that I'm wrong, but I feel certain that there's going to be unintended consequences, and in 2 years, you'll suggest that we make some changes. Thank you for taking my questions.
Thank you, Dean.
Senator Paxton, what purpose?
To ask the author a question.
Do you yield?
I yield.
Thank you, Mr. President. Thank you, Senator Creighton, and I appreciate the thoughtfulness you put into this bill. You know, as I was listening to your layout, I couldn't help but think about conversations that I started having with constituents contacting my office during the interim who are business owners in one or more cities in my district and outside my district who've been doing business in those cities for decades, sometimes family-owned businesses, right, generations, that now find themselves dealing with ordinances, not just that maybe they don't like or something, but they're frustrated because they're saying this ordinance is actually in conflict with state law. And yes, I guess I have a way to deal with this. I can file a lawsuit against my city, but why do I have to pay to fight for what is the law? Why am I having to fight my own city? And I wonder, I mean, are those the kinds of stories that are the soil that this has grown up from?
Those are exactly the kind of stories that we're hearing, not just through our offices, but we just had impassioned pleas through testimony in our committee hearings, not just this session, but now for several sessions from business owners all over the state, with example after example on how those patchwork compliance nightmares, cities out of bounds on their ordinance authority, just bringing anti-business ordinance after anti-business ordinance, not just hurting the large-scale businesses that many assume can digest the impact of that, which they can't, but hurting our small family-owned businesses that represent 75% of the businesses in this state, which is why it's an NFIB top priority for this session, as it has been for 3 sessions.
Well, I think it's good legislation, and really all we're saying is that just like we want citizens to be law-abiding citizens, we want cities to be law-abiding cities and municipalities to follow state law, so that business owners have they have predictability and they have fairness as they operate their businesses.
That's exactly right.
Well, thank you.
Thank you, Senator Paxton.
Oh, I thought we had already suspended, excuse me.
Am I recognized?
You are recognized. Do you yield? We thought the questions were over, so I'm sorry. Do you yield?
I yield.
I thought my light was on, it was off.
Yeah, because your name was, the screen was blank, so.
I apologize, Mr.
No
President.
problem.
Senator Creighton, this bill would go into effect, assuming that it's passed, when would it go into effect? Do you, off the top of your head, do you know? It's September 1?
I'm assuming it has a similar enacting clause, Senator West. We can confirm.
Okay. Here's the real question.
Depends on the vote threshold, I believe.
Okay, here's a question. Assuming this bill passed and signed by the governor, what happens to ordinances that are currently on the books of cities that are implicated by the various areas that you have in your bill? Those become null and void, or what?
The enacting clause is September 1st of 2023. During the House discussion, there was a similar question about some of the ordinances that were in play, and I believe that threshold date was any ordinances drafted before January of 2023, but before the beginning of session.
That those ordinances would stay in effect, or what? What are you saying? I'm not understanding what you're saying. You said any ordinances drafted before January 2023, would they stay in effect, or what?
Yeah, maybe I misunderstood your question, but yes.
Okay, so anything after that would be null and void.
Yeah, you're talking about, I thought you were talking about ordinances that aren't yet passed.
Okay, and so ordinances that are on the books right now would still be in effect?
That's right.
Okay, even if they touch these particular areas?
Well, it depends on the subject matter, right? It depends on the subject matter, right? Yeah.
Right, if the subject matter are matters that are covered in your bill under, I guess, Section 2.
So for payday lending, for...
No, I'm not talking about those. I'm talking about let me be more specific, sir. I just lost the bill. In your bill, you named several different codes that cities could not pass ordinances, correct?
That's right, unless it's found in the authority granted in the code.
Right. And so what I'm asking you is, as it relates to those areas in the bill, any law that has been passed prior to the implementation date of this bill, would those ordinances be effective, or would they be null and void? You follow me?
Yeah, I follow you.
To the answer to the question, you're checking?
Yes, yeah. I'm advised that there would be void, but that the cities can amend any ordinance that's in violation, and they have a 60-day right to cure.
All right, so then what we're telling cities, this bill becomes law, they would now have to do an extensive search of all of their ordinances to make a determination as to whether or not any of the existing ordinances need to be repealed, or whatever process they have in place deemed null and void, correct?
Yes, I think it would be pretty quick research to make that determination.
Why do you say it would be pretty quick research?
Because the types of ordinances these cities are pursuing are clearly known among city attorneys and TML and organizations on whether or not they're found in state statute.
All right, so then, obviously, under Section 102A002, cities would have to go through all of those different codes and make a determination as to whether or not they have ordinances that complied or consistent with those particular codes, correct?
That's correct.
And you think that would be a pretty quick process for the cities?
Yes, I believe that that TML and these cities work together on these agendas, and I believe it's clear whether or not they have the authority from the outset.
All right, let me ask you this question. If indeed a city found that there was a health and safety issue with one of these particular areas? Would they have authority to look at health and safety related issues concerning any one of these particular codes and make a ordinance? Or would that be void also? Did you understand the question?
That would be void also. I think, it depends on what's allowed, right? If it's tied to a specific rest break, well, then that would fall within OSHA guidelines for exactly what either OSHA or the CDC requires. So you have distinctions between all the different requirements that OSHA has handed down for just keeping workers safe in hot environments, as an example.
Well, you're reading my mind because we talked about it, but it would have to be a requirement, though, right? If it's not a requirement, then what?
Well, I think OSHA published, as of 2019, they published a little bit more advanced enforcement requirements on keeping workers safe, even though what they had prior to that was fairly comprehensive.
If indeed it's just a recommendation by OSHA, and would your response be the same?
Yes, because of that 2019 enforcement that they put forward, my response would be the same.
And so what you're saying then, that if cities in Texas, if it's in summertime, let's just talk summertime. If cities in Texas, let's, the following assumption, this law is in effect, and cities have workers dying on construction sites, which would obviously be an employment-related issue, subject to the labor code, the cities could take no action in order to ameliorate what's happening in their city without coming to the legislature. Is that correct?
Well, OSHA would continue to stipulate exactly what is needed, like in Region 6 under OSHA requirements. That would include Austin. They would have reporting requirements for serious injuries or death. And if this was a significant issue, OSHA would certainly have numerous and specific requirements beyond what they just published in 19 for enforcement, which is for keeping job sites safe in hot climates.
Well, again, it's my understanding that those are just recommendations, not rules that employers have to follow. Correct me if I'm wrong.
In 19, they stipulated more enforcement provisions, and in 2021, they launched an enhanced and expanded measure to protect against heat-related illnesses that includes establishing an enforcement initiative to prevent and protect employees from serious heat-related illnesses and deaths, and it expands on the agency's ongoing heat-related illness prevention campaign set forth with a strict enforcement component. It launched a rulemaking process to develop a workplace heat standard, developed a national emphasis program on heat inspection, and formed a heat work group to engage all stakeholders. It was a 44-page guidance document that had strict compliance enforcement provisions.
All right, so follow me with this then. If indeed there's a problem, then the city would have to go to OSHA and report it, and then OSHA would then be required, or OSHA, under its investigatory powers, would then come and investigate. Is that how that would normally work?
Yes, the city could report it, but also reporting could be in the private sector as well. Yes, there's different opportunities depending on the reporting side of those requirements, but the city would be one of them.
All right, thank you, sir.
Thank you, Senator West.
Following motion in writing.
Motion in writing, Mr. President. I move suspension of Senate Rule 11.13 to permit the Conference Committee on House Bill 1 to meet during today's session. Motion by Huffman.
Members, is there any objection? Hearing none, so ordered. Senator Johnson, for what purpose?
Quick question of the author.
Does the author yield?
Yes, I yield.
One little question and one larger question. The little question is, can cities regulate fireworks displays under this bill?
Absolutely.
No problem with fireworks displays. And how would I figure that out if I worked for the city?
How would you advise them on whether or not that is clear?
Don't mean to interrupt you, I'm sorry. If I'm working for the city and I'm trying to figure out what I can and can't do, and I'm looking at whether or not I can regulate a fireworks display, what's the process I go through to make sure I don't run afoul of this new law?
I think first and foremost, Senator Johnson, I believe just, the city attorney researching either through the local government code or the code where that field exists, also relying on their TML representative, which also has a team of attorneys that can advise on if state statute allows that authority, or relying on their very capable state legislator.
Ooh, that's a big one. It actually is one of the things I'm concerned about is all of us capable state legislators are going to be doing a whole lot of work for cities that we've previously outsourced under 111-year-old doctrine of home rule. And I know it's not your intention to wipe out cities altogether, but many of us have expressed concern that that's effectively going to be the result, and it's going to shift the burden to us. And the state doesn't exactly have a good record of thinking of everything that ever can happen. So, speaking of which, you referenced the Constitution many times here. Are you familiar with the case called BCCA Appeal Group versus City of Houston?
I might be more familiar with the ruling, but no, not the case.
We won't have space to bring it up here, but I wonder if in the course of drafting this, if the question came up about the difference between field preemption and conflict preemption, and I believe that in that case, the court found that home rule cities are subject to conflict preemption, but not to field preemption under the Constitution. And this bill seems to get rid of that and say, nope, they're subject to field preemption, not conflict preemption. Am I correctly characterizing your bill, aside from the constitutional problem I'm alluding to?
Yes, and Senator Eckhart and I had that similar exchange. So to your first question, as a hypothetical for your second question, fireworks can still be regulated by the city based on Chapter 342 of the Local Government Code. Cities can also regulate outdoor festivals that may have a fireworks display. And before this bill was passed, depending on if it's a home rule or a general law city, one had to find authority or else otherwise prohibited. One could act if it wasn't specifically prohibited. This legislation changes that, and I hope that answers your question.
I think so. So actually in the local government code itself, it provides authority to the cities to regulate fireworks displays?
Yes.
Does the local government code permit cities to create sanctuaries for the unborn? Or are they going to be violating state statute or this bill if they do that?
You and I would have to go through all of the code together for all the different nuances, but it would just be up to them to determine that. I think it would be more clear than not in the examples, and if they found it to be not clear, they would either have to seek redress through a judge in a declaratory judgment or come back to the legislature and say, this exact example is not real clear here. I know the spirit and intent of 2127 was for us to approach through TML or other organizations. We need clarity, but we're not going to pass the ordinance until we get it.
Okay, and if it's okay with, I feel like it's okay with the president and chair up there, I will skip statement on third reading and make a statement now. And the first is that I'm not just sympathetic, I'm in some ways supportive of some of the motivations behind the bill. I do think particularly in coastal cities, we see this competitiveness among layers of government, and it just strangles a lot of things, economic and non-economic, and we don't want to be that in Texas. And I think we do have instances of cities, small and large, overreaching. But we also have a history of the state not doing things that need to be done, and the cities become exasperated, and they take it on themselves. And we've now shifted the balance away from deferring to cities, and sometimes they overreach, to kind of preventing the cities from doing things that many people have relied on them to do. And then it falls upon us to pick it up. And I think that's going to be difficult. And this is the statement part. And of course, you're welcome to respond. But I am concerned that we're not going to have the bandwidth to think of all the different things that cities would be looked upon to do that they're not going to be able to do. And that things will arise among our constituents that we're not going to know about because they're going to call their local city elected official to handle it. And we're just not going to be able to keep track of it. So as we've shifted this pendulum way over to the other side, I agree with Senator Whitmire that we're probably going to be back here in 2 years trying to correct the balance again. So I don't condemn altogether the sentiment here. I think it is important. But I do fear that we've gone too far and we've rendered our cities less than what they should be.
Well, Senator Johnson, I understand your concerns. My door's always open to work with you on adjustments that are needed, as we did with payday, as we did with animal regulation and other clarifications. We may very well need more.
Thank you, Senator Creighton.
Senator Creighton moves suspension of the 3-day rule. Correction.
Regular order of business.
Sorry. Senator Creighton moves suspension of the regular order of business. The secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez.
There being 18 ayes and 13 nays, the regular order of business is suspended. Chair lays out on second reading House Bill 2127. The secretary will read the caption.
House Bill 2127, relating to state preemption of and the effect of certain state or federal law on certain municipal and county regulations.
Following amendment, the secretary will read the amendment.
Floor amendment number 1 by Creighton.
Senator Creighton, you're recognized on the amendment.
Thank you, Mr. President. Members, this amendment ensures that if a plaintiff loses their suit against a municipality, they would be responsible for legal fees. This loser pays provision creates a guardrail so counties and municipalities are not subject to frivolous lawsuits or countless cases that hold the public liable for cases filed.
Just hold them. Don't send anything else. You shouldn't have been sent.
Senator Creighton brings an amendment. Is there objection to adoption of the amendment? Hearing none, the amendment is adopted. Following amendment, the secretary will read the amendment.
Floor amendment number 2 by Creighton.
Senator Creighton, you're recognized on the amendment.
Thank you, Mr. President. Members, this amendment makes it clear that no single municipal or county official as an individual may have a suit brought against them as an individual.
Senator Creighton brings an amendment. Is there any objection to adoption of the amendment? Hearing none, the amendment is adopted.
Yeah.
There is an amendment. Secretary will read the amendment.
Floor amendment 3 by Eckhart.
Senator Eckhart, you're recognized on the amendment.
As we discussed previously, the case law up to this point interpreting the Texas Constitution with regard to home rule cities is that a home rule city can do anything, to take any action that's not specifically prohibited by state statute. Because this bill flips that script and says that even home rule cities can only take actions that are specifically allowed by state statute. What this amendment does is it clarifies what occupying the field of regulatory authority means for the bill. You heard Senator Johnson also talk about conflict preemption versus field preemption. Under the case law as it currently exists, home rule cities are conflict preempted, but this bill seeks to preempt under authority as well. So this bill clarifies that by saying, it simply defines what preemption is. A field of regulation is considered occupied by provision of this code if a party can show that the state has adopted a comprehensive set of laws or regulations governing the challenged field of regulation. By amending the bill thusly, it would solve the ambiguity about whether, if the state says nothing, does that mean they have preempted? Or if the state has only lightly touched in an area, does that mean the state has preempted? This amendment would require a comprehensive set of laws regulating the regulations governing the challenged field of regulation.
Senator Menendez, for what purpose?
Questions of the author of the amendment?
Does the author yield?
Yes.
Thank you, Mr. President. Thank you, Senator Eckhart. Senator Eckhart, I've been reading your amendment and I've had similar questions in terms of the ambiguity about what could be left up to, if it's not spoken into in state law, could someone bring a lawsuit forward and then possibly win the lawsuit against the city, and then there's taxpayers are on the hook. And we just heard, an amendment, a good amendment by Senator Creighton to say loser pays. But then this language in your amendment would clarify the bill to make it to where a lawyer could look at something and maybe tell their client, I'm sorry, the law is clear as in terms to the field, and it clarifies. You don't have a case, and maybe that would also save taxpayers money by not filing frivolous lawsuits. This amendment doesn't do anything to water down the bill, it clarifies the bill. Is that correct?
That's my intention. And already under the bill, as Senator Creighton presents it, an individual or an entity has to bring a lawsuit in county court to find out whether or not the local bill conflicts with state legislation or is preempted by state legislation. This doesn't change that. It simply says that preemption means substantial regulation in the challenged field of regulation. And I'll give you an example. Senator West raised the issue of water breaks, and Senator Creighton said that's addressed by OSHA. It is, to some degree, addressed by OSHA, but OSHA states plainly in its regulations it does not have a minimum water break requirement. And state law does not have a minimum water break requirement. So if a local governmental entity establishes a minimum water break requirement, even just for construction of its own buildings, a contractor could challenge that and possibly win that challenge in county court or district court because the state legislature says nothing about water breaks. So this bill seeks to clarify that, to say, to be preempted from local action, the state must have a comprehensive set of laws or regulations governing the challenged field of regulation.
What about where we may not have a full body of law determining what's fair in terms of the annual percentage rate and loans? Personal loans. We know high interest credit cards can be in the 20s, 30s, but average payday loans are in the hundreds of percentage rates. And many times they prey on low income, on the military and others. And so my understanding is that even though the current bill is drafted, it grandfathers in current payday lending laws in the cities. It would not allow for any new or any adjustments to those laws. Let's say currency changes or the way those laws are addressed, or maybe now you can make the lending directly to your phone. Does that adjust? Your clarification would say that since there have been local laws in that field, and they can continue to adapt those as technology changes. Is that an accurate statement?
That also is a good example. Under the law as presented by Senator Creighton, some home rule cities that do have payday lending regulations would still get to operate under those regulations, and other home rule cities who don't would not get to adopt anything until the state does. But you're right, for those who already have payday lending rules, the industry is changing so fast that a municipality might want to tweak their current payday lending rules in a time when the state legislature has not occupied the field.
Correct.
And so, again, this would simply define occupying the field.
I appreciate you bringing this amendment forward. I'd read it as a perfecting amendment because it helps reduce ambiguity in the way the law will be applied.
And my hope is it also provides a marker for jurists as they're adjudicating these cases to say, there has to be a comprehensive set of laws or regulations governing the challenged field. It can't be silent or just a slight touch in that area.
Makes a lot of sense. Thank you very much. Thank you, Mr. President.
Thank you for your questions.
Senator Creighton on the amendment.
Thank you. Local governing entities to act within the authority granted to them as state Constitution is the exact reason why those entities would need to approach the legislature for anything that affects state wide impact on businesses, and for that, I would oppose the amendment.
Senator Eckhart to close on the amendment. No close?
No, he didn't table it. It's
Just a question. Members, Senator Eckhart sends up an amendment. The amendment is not acceptable to the sponsor. Is there objection?
Secretary will call the roll.
There is. Secretary will call the roll.
Alvarado, Betancourt, Birdwell. Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez, Hall, Hancock, Hinojosa.
There being 12 ayes and 19 nays, the